So good afternoon. I'm Matthew Greco. I'm the events manager here at PSS Life University. And as you know, we have David Cutner here today, the founding partner of Lamson Cutner, one of New York City's leading elder law firms. Known for his deep empathy, legal expertise, and practical solutions, David is highly regarded for helping elderly and disabled clients protect their assets and secure the care they need.
Welcome, everyone, and thanks for joining us today. As you can see, we're going to talk about the Medicaid program, the Community Medicaid program, and institutional, otherwise known as nursing home. So, and thank you, Matt and PSS, for hosting our event today. And let's get started. So I think this is really a good place to start any discussion about Medicaid, because it's mainly going to be called upon when you need long-term care. And I think a lot of people don't realize how big a risk this is. I really think that for most people, your health care, your long-term care is probably your biggest financial risk. As you can see on this slide, and I took this from the U.S. Department of Health, 7 out of 10 people will need long-term care of some kind at some point in their lives. And 4 out of 10 will need nursing home care. You know, those are not great statistics. And particularly when you couple them with the cost of long-term care, you have a serious financial risk. We all do. A lot of people think that, well, I've got Medicare, I'm fine. Medicare is supposed to cover all my health care needs, right? Well, not exactly. It surprised me when I saw this article in the New York Times last year that 45% of people 65 or older thought that their Medicare would cover long-term care. Well, it does not. Medicare is great for your medical insurance and for rehabilitation and other things, but not for long-term care. So who does pay for long-term care? Well, you do, if you haven't made any plans otherwise. And as I said, it's very expensive. You may have long-term care insurance. Not very many people do. I think less than 3% of our population has long-term care insurance. And for many of those who do, at least from what we see in our law firm, oftentimes that insurance is really not very good because it doesn't provide enough. So it's one thing to say I have a long-term care insurance policy. It's another thing to really be clear about what the daily benefit is and what the lifetime maximum is, because I see all the time people with, $100, $150 a day benefit. That doesn't go very far. That'll pay for 3 or 4 hours of home care, but that's about it. What if you need assisted living or nursing home, where the cost could be $500 a day? So if you only have $150 a day of insurance, where's the rest of the money coming from? Well, chances are it's just draining your savings at a slightly lower rate. So then there's Medicaid, which is the main topic of our conversation today. So I know a lot of people are sort of turn up their nose or feel a little suspicious about Medicaid. They think that, it's going to be second-class care or things like that. So let's know a little bit about our Medicaid program. As you can see on this slide, unlike Medicare, which is a federal healthcare program, Medicaid is a partnership between the state and the states and the federal government. And the program is administered by the states under state law, and it matters very much where you live because the laws are different and the financial contributions of the states differ dramatically. New York's program, I have no hesitation in saying we have the best in the country by far. We put more money into our program, both in total dollars and per capita dollars. Compared to many states, we spend 25 times more per person than they do, just to give you an idea of the magnitude of difference that exists around the country with regard to Medicaid. So you can see we've got broad coverage in New York, and bear in mind as well that there's no such thing as a Medicaid facility. None of the nursing homes, none of the assisted livings, none of the home care agencies, none of them are owned or operated by the government. It's all private business, and private business that has agreed to work with the Medicaid program. So we have two main categories of Medicaid benefits. One is the community side, Community Medicaid, and the other is nursing home. And we divide them, or at least I divide them into these two big categories mainly because of the difference in the application, which we'll talk about in a moment when you apply for the benefit. So you see for Community Medicaid, we've got home care. The CDPAP program is one where you can select your own aid rather than working with an agency. We've got adult daycare, we've got assisted living, we've got special programs for special needs like traumatic brain injury and Lou Gehrig's disease and other things. I mentioned the nursing home transition program that is currently paused at the moment because there's so many people who signed up for it. Medicaid is not prepared to take any more at the moment, and hopefully more spots will open up. The idea of that program is essentially to bring the nursing home to your home. So if you're someone who would rather stay home but needs a high level of care, that's a really good choice when it's available again. On the nursing home side, of course, you have your care in the nursing home completely covered by Medicaid. And as I've already said, it's very expensive. Typically in the New York metropolitan area, we're looking at spending $15,000 to $20,000 a month on nursing home care, private pay. It's expensive. All right. So just a brief word on what Community Medicaid does not cover. And these are services that oftentimes are needed. Of course, Medicaid's not paying your ordinary living expenses. They're paying for your care, but they're not covering your financial advisor or your care manager or supplemental home care or legal or accounting. Good idea to bear all of that in mind. So let's get to the main event here, which is, how do I qualify for Medicaid? Well, your eligibility for the community program is based on what Medicaid calls your resources. And for the word resources, we could substitute the word assets. So we really need to distinguish here between assets and income, because again, the eligibility is based on assets, not income. That being said, it's not every asset. You can not be concerned about what's in your jewelry box or your stamp collection or your car or all of this kind of tangible personal property. Medicaid doesn't look at that or count that, but they will look at all of your financial resources. So your checking, your savings, your CDs, your stocks, your bonds, your insurance policies, your everything that you have of a financial resource will be counted, and you need to stay under that number right there on the screen, 32,396. That's the current number. We understand that it may change a bit this year. If it does, it won't be by much. Might be a couple of $100 higher or so, but best to think that it's about $32,000. You can't have more than that much money in your own name. As I already said, your income is not an eligibility factor. There is a so-called limit. I say so-called because you're really not restricted if you join a pooled income trust, which is a way of protecting your surplus income, the amount above the Medicaid limit. So it's like having another bank account that you can use with one limitation, which is you need to spend that money on yourself. A lot of people ask about the look back, and we will talk about the look back in connection with nursing home care, but there is no look back for Community Medicaid. There never has been in all the decades that we've had Medicaid here in New York. There's never been a look back. Back in 2020, the legislature thought it would be a good idea to have a 30-month look back for Community Medicaid, but it has never been implemented. They're not really even talking about it anymore. I don't think it's ever going to happen, but who knows? Anyway, we have no look back for Community Medicaid. Now let's take a look at Nursing Home Medicaid. So the resource number is the same, $32,396 at the moment. The income is treated differently, although it still is not an eligibility factor. However, Medicaid's position is if you are in a nursing home and we're paying the bill, then you don't need your monthly income anymore because you don't have any expenses. So you only get to keep $50 a month out of your income, whatever it may be, and the rest you need to contribute to the cost of your care in the nursing home. So that's called you'll hear it called the NAMI, which refers to the net available monthly income. Now, if you're married and your spouse is still living in the community, then he or she is entitled to what Medicaid calls a minimum monthly maintenance needs allowance. So that will look at the community spouse's income, and if his or her income is not at least $4,066, then the community spouse gets to receive money, income from the spouse who's in the nursing home. All right. Again, the MIMNA, it's referred to as the MIMNA, that's the needs allowance, currently $4,066. So if the community spouse, let's say, has $3,000 a month of her own income, she would be entitled to $1,066 of her husband's income when he's in the nursing home and covered by Medicaid. And if her income were $5,000 a month, then she would not be entitled to anything from her spouse who's in the nursing home. All right.
Can I ask a question, David?
Yes, you can. Go ahead.
Okay. Does your Social Security go to the nursing home?
Yes, it does. Your Social Security is ordinary income, along with your pension, your distributions from your retirement plan, the RMD, required minimum distribution. Yes, all of that goes to the nursing home.
Okay, great. Thank you.
All right, so I was about to focus now on the look back. And the look back is what distinguishes the nursing home eligibility and the nursing home application from Community Medicaid. And it's a really important one here. So if you are in a nursing home and you are otherwise eligible for Medicaid. So when I say otherwise eligible, that means that you have less than $32,396 in your own name. So you're otherwise eligible, but if you have made gifts or transfers of your money or your property during the 5 years preceding the date of your Medicaid application, you will be ineligible for Medicaid benefits for a certain period of time. And that period of time will be calculated from the amount of the gift or the value of the property that you transferred to somebody else. And this is called the penalty period. So by the way, a lot of people are concerned that if they transfer or gift money or property, they're going to get in trouble or somebody's going to get sued. That's not the case. All right. There's nothing illegal or improper or unethical about making gifts or transfers of your money or your property. All that Medicaid is saying essentially is if you have money to give away, that's money that you could have used to pay for your own nursing home care. So why should we pay for it if you're just giving your money away? So that's what the look back is about. They will calculate a period of time where the gift or the transfer that you made arguably could have paid for your care. That's what the look back is about, and we're going to take a closer look at it now. So when you file your application, Medicaid will see, because of all the documentation and information that you have to provide, and from the fact that they have your Social Security number and they can check whatever bank accounts or investment accounts you may have. So they'll know what assets you have transferred if you did that during that 5-year look back period. Then they will divide that number by the so-called regional rate. And the regional rate is what Medicaid puts as kind of the cost of nursing home care in the county where you live. That's the regional rate, and I'll show you that in more detail in a moment. So if we divide the amount or value of assets transferred by the regional rate, that gives us the period of ineligibility, the penalty period. So that penalty period starts when you're in the nursing home and you're otherwise eligible, but for the penalty. So here are the regional rates for local counties. You can see they're all a little above $15,000. That Westchester number applies to other local counties going north and west, like Putnam and Dutchess and Rockland and some other counties. As we go further upstate and further west toward Buffalo, that number will come down a little bit. The cost of nursing home care is a little bit more expensive in the New York metropolitan area. But you can see it's around $15,000. So here's an illustration so you can kind of see exactly how this works. So in my sort of hypothetical story here, mom lives in New York City in a rental apartment. She's not doing well. She's got some Alzheimer's disease and some other medical problems. She's thinking about getting some care in the home, but she has about $400,000 in savings. So in December of 2023, she transferred most of her money to her children. And she left herself with just a small amount and paid a few bills. And then she was eligible for Community Medicaid. So she filed a Medicaid application and she qualified and she got a home health aide. A couple of years later, she had a bad fall and broke her hip. She had to have surgery. She was in rehabilitation. And meanwhile, her Alzheimer's got worse and she had other problems, health problems. And she just at that point was not a candidate to go home. And bearing in mind that at a rehab facility, they have to make a safe discharge. And there really wasn't any choice. She had to go to a nursing home. So by that time, she only had $25,000 in savings. She was under the Medicaid eligibility level, which we saw was $32,396. So she's in the nursing home. She's otherwise eligible. She applies for Medicaid nursing home benefits. So what happens? Well, looking at the application, Medicaid sees that 2 years earlier, she transferred $370,000 to her children. So Medicaid took that number and divided it by the regional rate for New York City, where she lived. And the arithmetic showed that she was ineligible for 24 months. So what now? Well, she's in the nursing home. Somebody's got to pay the bill. So the kids who had been sitting on that $375,000 or $370,000 now have to use that money to pay mom's nursing home bill. And at $15,000 a month, it's all going to be gone after the 24 months that constitutes mom's penalty period. So you can see that the consequence of making gifts and transfers that become subject to the Medicaid look back if you need nursing home care. So let's think about what we can do to protect our assets and at the same time achieve eligibility for Medicaid. And I think that point in red here on this slide is really important. Thinking about this early on is a good idea. Those who plan ahead usually have better outcomes than waiting until the last minute, and largely because of that look back problem. And I know for most people, nobody wants to go into a nursing home, but I know from experience in my own family and from many clients that lots of folks who say, I'm never going into a nursing home, somehow wind up in a nursing home because it's the only safe place to be at some point. Anyway, what can we do? Well, first thing that we always like to do in our law firm is see whether there's a possibility of an exempt transfer. And we'll look at that in a moment. If there is no possibility of an exempt transfer, we want to move savings and other assets out of our name to get down or at least close to the Medicaid eligibility level. So here's a look at exempt transfers. A blind or disabled child, a trust for the sole benefit of a disabled person who's under 65. Spousal transfers are exempt transfers in New York, but in most cases, the spouse is going to have to sign a Medicaid form called a spousal refusal, which essentially says, I recognize I have a legal obligation to support my spouse, but I refuse. I'm not going to make my income or my assets available for that purpose. And if a spouse does that, Medicaid is legally obligated to provide the care. But the problem here is that once having provided the care, Medicaid has an opportunity later on to ask for reimbursement from the spouse who had refused. So there's kind of a lot more to this story about spousal refusal. I don't know how much time I really have to go into that today. But just very quickly, when we do see demands for reimbursement from Medicaid, those demands typically get negotiated and compromised, often at 50 cents on the dollar or even less. And bear in mind as well that Medicaid's claim for reimbursement is based on their cost, not what the private pay rate would be. So you're kind of getting an upfront discount plus your negotiated settlement. You still can come out pretty well with a spousal transfer if that is kind of the only available strategy. So looking at the others, there are times when a child is living at home with the parent. That child is by definition a caregiver child. And in that case, it's an exempt transfer for the parent to give ownership of the home to the child. Or maybe a sibling has an equity interest, and that equity interest might only be 10% or 2% of the value of the property. And we can have another exempt transfer there to a sibling with an equity interest. And finally, I put on this slide a caregiver agreement, which means that you have entered into an agreement with somebody to provide care. That somebody might be a child who's already providing care to you or companionship, and that person could be paid for doing that. So it's not exactly an exempt transfer because there is some sort of quid pro quo, if you will, but there's an opportunity in effect to transfer some money to your child or a sibling or a friend who's helping you out.
Okay, wait, David, sorry, before you move on.
Yep.
Somebody had a question. The question is about gifts. If you have, do small amounts given away for birthday gifts, for example, count as transfers?
Oh, so how does Medicaid look at a small birthday gift or a holiday gift kind of thing?
Yes.
Well, typically they're not looking at gifts and transfers under $2,000. So if you've given $100 or $500 to your grandson on his birthday, that's really, I don't think, going to have any effect on your application. Now, if you gave out 100 gifts of $500, that might look a little bit different. But, I think an occasional gift on a birthday or a holiday is probably not going to have any consequence for you.
So it's actually a little bit, it's a little bit open to question. It's a little bit of a gray area. So that's something that you want to be cautious about and talk to somebody about before you go too wild.
Well, I guess, there's no real rule about this, but, we just know from practice and having filed hundreds of applications for clients, it's kind of obvious they're not looking at the small numbers like that. It's basically they want to know about transfers of $2,000 or more.
Okay. And
so,
and actually, sorry, and there was another related question. Sorry, I don't want to interrupt you.
Yeah, go ahead.
So at first I was thinking this was an estate tax issue, but it's not. It's an issue with this. So if you were taking, it's a tax related question. So if you've been filing your income taxes and you have been taking the standard charitable deduction on your income tax form for the last 5 or 6 years, will that count as a transfer? I think the answer is yes, right?
I'm really not sure what the question is. You're claiming a standard deduction on your income tax return?
Yes, for charitable deductions. So those are gifts.
Well, I'm not aware of that having been a problem. I'm not 100% sure about that, but I would be surprised to hear that that's a problem.
Okay, thank you. Good. And sorry, and somebody who is that, yes, I see they unmuted themselves. Somebody who is on the phone has had their hand up. So person with your hand up, you want to talk?
Yes. Hello, this is Daniel Aliberti. I had a quick question, and that spousal transfer. Is there a time frame if the person, for instance, just got married a month ago, or must they be married a certain length of time? What is, because I know there are nowadays with issues of immigration and citizenship and all sorts of things, there are time frames. Is there a time frame that the person must be married before they can do a transfer?
No, I think you're either married or you're not, Daniel. The thing is that, under our laws, your obligation to your spouse, you owe an obligation of care and support in the same way that, parents are legally responsible for the support of their minor children. So once you're married, you can make a spousal transfer, and your spouse, if you're applying for Medicaid, would probably have to sign a spousal refusal.
So in some cases, this would be an interest of somebody to get married if they weren't.
Well, I don't know.
But okay, I understand. Thank you.
Any other questions right now, Cindy? You're on mute now.
No, yeah, sorry. There's one, but it's kind of it's kind of long and complicated. So I think I'm going to hold that one till the end. That was Judy Cal. I'm going to hold your question to the end, Judy, because it's going to be sort of complicated, and I don't know if we'll have time for it, but we'll try and get to it. Okay, so
all right,
that's it.
So let me move on to the next slide then. So here's a question that we hear all the time: isn't my home exempt? And I also know that there have been probably a fair number of cases where people acted on the idea that their home was exempt, only to be unpleasantly surprised down the road. So here's the story on the home exemption. So if you own your own home and you're living in your own home, and you're applying for Community Medicaid, so you're asking for care in the home, right? You want Medicaid home care, all right? And your equity in the home is no more than $1,130,000. Medicaid is not going to look at the value of your home in determining your eligibility for Community Medicaid. All right. But what's really important here is the fact that your home is your primary residence. The problem arises when the home is no longer your primary residence. And what are the chances that your home will one day no longer be your primary residence? Well, 100%. We know that for sure, right? Because one day you're going to move out of your home, either because you died or because you moved to a nursing home, or you moved in with your children, or you moved to an assisted living. But something is going to happen in your life where your home is no longer your primary residence. When that happens, the exemption is lost immediately, and further, Medicaid has the right to recover reimbursement of all of the money that it has spent on caring for you from the equity in the home. They can put a lien on the home, and they do. They can collect from your estate if you passed on. They would be a creditor of the estate. Further, if you move into a nursing home, then your primary residence, the home is no longer your primary residence. It lost its exemption. It's immediately a Medicaid resource. So you're not going to qualify for Medicaid benefits in the nursing home. because you own a home that is not exempt. So please, 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 if you're applying for Medicaid, and I'm talking particularly community, don't be misled by the idea that your home is exempt. That is the time to transfer ownership of your home to a trust. All right. So, should I have a plan for long-term care? You bet you should. And again, I'm referring to the statistics from the U.S. Department of Health. And the fear really, and it's a very legitimate one, that if you need long-term care and you've got to pay for it yourself, there goes your life savings. So where does that leave you or your spouse or your children or whoever else may be counting on you if you need to spend all of your money on your long-term care? So long-term care planning, we want to assure that you can get the care that you need if and when you need it. We want to protect your assets and your income against those very expensive costs. And at the same time, it'd be nice to protect your estate. So we know that you'll have something to leave to your spouse, your children, or whoever you want to benefit. So I think, as we've already seen, the way that you become eligible for Medicaid is to reduce the assets in your name down to the Medicaid level, which is admittedly a small amount of money, currently around $32,000. So if you need to do that or feel that's a good plan, what should you do? Should you transfer your money and your property to an individual, a child or your children or a sibling or a best friend, or to a trust? So let's just talk quickly about what is a trust. A trust is an entity, like a corporation or a partnership or an LLC, except trusts do not have owners. Corporations have shareholders, partnerships have partners, and so on. Trusts do not have owners. And at the end of the day, unlike your will, which must be submitted to the surrogate's court with a probate petition in order to get anything done, there is no court proceeding needed with a trust. So it starts with an agreement between the person who's creating the trust, usually called the grantor, and the person who's going to manage the trust, called the trustee. Or in some cases, we have co-trustees or multiple trustees even. So the trust can own anything: real estate, co-ops, cash securities, stamp collections, anything, art collection. And if your goal is Medicaid eligibility, you're going to need an irrevocable trust, which I'll talk a little bit about. So the irrevocable trust in this context is typically called an asset protection trust or a Medicaid asset protection trust. You're really separating yourself from your money and property when you create this type of trust. Think about the trust as another person. You know, you're transferring your home, your investments, and so on to a different person, the trust. And you're no longer in charge and control And it has to be that way, because if it weren't, Medicaid wouldn't recognize it, and nor would your creditors. That you can properly and legally say that assets in your irrevocable trust don't belong to you. Not mine. It belongs to the trust. If I created a trust, let's call it the David Cutner Trust, and I prepare a deed and I transfer ownership of my house to the trust, and I put my investments in that trust, all of that property is not mine anymore. It belongs to the trust. And that's why it works, by the way, with Medicaid and with potential creditors. It's not mine. Okay, so here are the benefits of doing this type of trust. Your assets are protected against creditors during your lifetime. The trust ownership facilitates eligibility for Medicaid and access to Medicaid benefits. Unlike a will, there's no probate, there's no court involvement. When you pass on, your assets can be distributed according to your instructions in your trust. That's done privately and without delay, or, well, I can't say with no expense, but with little expense. And your beneficiaries will get a nice benefit of receiving all of their bequests at fair market value. So they don't have to pay any capital gains tax on the appreciation and value of the assets that accrued during your lifetime. And just to be a little more specific about that point so that everybody understands, let's say mom and dad bought a house 30 or 40 years ago and they paid, I don't know, $50,000 for it. And today that house is worth $1 million. Well, if they sold the house during their lifetimes, they would pay a lot of capital gains tax. But if you inherited that house from them, you receive it with $1 million value. And if you sell it for $1 million, you have not realized any capital gain, and therefore you pay no tax. That's what tax lawyers call a step up in basis. So your basis is your investment in the property. Mom and dad had a $50,000 basis. You inherit it, you have $1 million basis. Okay, so we know from long experience with clients that a lot of people are, well, not so happy and comfortable about giving up control. And as I've already said, if you're going to have an irrevocable trust, that's something that you must do. You must give up control to your trustee. However, there are some aspects of this that maybe provide some comfort. If you've transferred income-producing assets to your trust, you can still receive all of the income. So you moved your investments into your trust. They produce interest and dividends. You can still get all the interest and dividends. So nothing has really changed in your income. If you've transferred ownership of your house or your co-op or your condo to the trust, you can retain the right to use and occupancy of your residence for the rest of your life. And you can retain the right to change the beneficiaries of the trust if you change your mind about anything in future years. You can exchange property if you wish of equal value. And there's sort of a a way of gaining access to principal amounts by giving your trustee the ability to distribute principal, not to you, but to someone you trust, to use that distribution for your benefit. So these are all aspects of creating a trust that, we would discuss in detail when we do that. And I think it's useful to consider how does this compare to making a transfer to a family member or friend, which obviously doesn't require the legal work of setting up a trust and appointing a trustee and so on. But we have to be ready to accept the risks that are involved here. And I'm putting aside here the integrity risk, okay? We've chosen someone who we trust, all right? So I'm not suggesting that. But that person who we trust can have problems in his or her life. Maybe there's a divorce in their future. Maybe they predecease you. So the assets that your assets that are in their name are now in their estate. Maybe they have some adverse financial developments in their own lives, and they're facing debts or lawsuits and so on. Your money is exposed. And finally, your beneficiaries, or they, would receive no step up in tax basis. They would be hit with capital gains tax if it's applicable. Because if you transfer during lifetime, it's not an inheritance. So you're the person who received that asset from you during your lifetime receives it with your tax basis. So in my example, if mom and dad transferred the house to you during their lifetime, you have the same $50,000 basis in a house that's worth $1 million. So later on, if you sell it, you're going to get hit with all the capital gains tax. So,
Wait, can I ask a few questions?
you can. I think this might be the last slide here. Yeah.
Okay. All right. So finish, and then I'll ask you the questions.
So this is what we believe to be a successful plan. We have a good irrevocable trust. We've avoided the risks of transferring money and property to individuals. And we've protected our assets against creditors and all comers during our lifetime. We have facilitated Medicaid eligibility. We have no probate. We have no court involvement. Assets are distributed according to your wishes privately and without delay or expense of a court proceeding. And we have that nice step up in basis for our beneficiaries who avoid capital gains tax. So that's the picture of what we regard as a really good plan around this whole long-term care issue and other issues at the same time. Okay, Cindy, questions?
Okay, the questions are, so first I'm going to ask the question, these questions are regarding the irrevocable trust. When the person with the irrevocable trust passes, does the beneficiary need to change the deed if they are selling the property?
Well, when the grantor of the trust dies, the property is owned by the trust. All right. So the trust can sell the property and distribute the sales proceeds, the net proceeds, to the beneficiary or beneficiaries, or depending on how the trust is written and the wishes of the grantor, the ownership of the house could be transferred to a beneficiary who could then either occupy it himself or herself, rent it, or sell it.
Okay, so the trust actually has the right to sell a piece of property without, because the deed has already changed. The trust owns the piece of property.
Right. Well, the trust would have no control of the property and nothing to say about it if it didn't own it.
Right. Okay.
So, when you create that trust in the first place, the trust agreement, your next step is to fund that trust, move the assets into the trust. So, if you own a house, then we would be preparing a deed to transfer ownership of the house to your trust. But
Right.
Look, it's kind of up to the grantor, the creator of the trust. Maybe he wants to leave the house to a specific person, and the trust would say, upon my death, my daughter gets the house. All right. And in other cases, there's no direction. So now the trustee is probably going to decide to sell it and distribute the proceeds.
Yep.
Okay.
Yeah. Good. All right. Regarding capital gains taxes, if the house is transferred many years before you die, so I'm the grantor, I put my house into a trust. 20 years, I don't die for 20 years. So does the trustee have to pay capital gains taxes after those 20 years because it's been in the trust for 20 years?
No, not at all. Because when the grantor dies, the property gets a new tax basis, which is equal to fair market value as of the date of death of the grantor.
Right. But because, and I think the point is that that house is not actually inherited until the death of the grantor.
All right. If the house were sold during the lifetime of the grantor, then yes, capital gains tax would be due.
Right. But if it's not sold until after the grantor dies, the step up in basis occurs at the time of death of the grantor.
Right.
Yeah.
But let's say that you have inherited the house from the trust and you decided to reside there for 10 years or used it as an investment property for 10 years, and now it's worth $1.5 million. All right. So your basis would be $1 million. But if you sell the property at that point, you have a $500,000 gain.
Yep. Okay.
Taxable gain. Yeah.
Yep. Okay. Then, does the irrevocable trust apply immediately, or can the trust paperwork be set up for some future time?
Well, a trust that doesn't own anything doesn't mean anything, right? So if you're going to do a trust, it's an empty shell, you haven't accomplished anything. Except, I guess you could decide 5 or 10 years later, okay, let's put some assets into this trust. But I'm not sure why you would bother unless your intention is to fund it.
Okay. Well, some people do set up a revocable trust, right?
Well, a revocable trust is purely an estate planning trust, which is designed to avoid probate. But even with your revocable trust, it doesn't do anything if it's not funded.
Right.
You have to move the assets into the trust because
Right.
the trust only governs what it owns.
Yep.
Right? So if you've created a trust, whether it's a revocable trust or an irrevocable trust, and the house is still in your name when you die, it's a probate asset. And you're going to have to go to court.
Yep. Great. So these are very good questions. All right. What if the trust company folds? Trust company folds. I think that you maybe talk separately about the pooled income trust and the irrevocable trust.
I don't know. What trust company are we talking about?
I assume they're talking about the pooled income trust company.
I don't know why you're assuming that, but
because there is no trust company for the irrevocable trust. There is no company that could fold. It's not a company. It's an agreement between parties.
Well, if we're talking about a pooled income trust, these are all nonprofit organizations that are licensed by the state. I haven't heard of any of them going out of business. I don't know that that's ever happened.
Mm-hmm.
But what we're talking about there is your monthly income, which, that's not an investment vehicle. You have that money going in every month and you basically want to spend it every month.
Yeah. Okay.
So you shouldn't be, you certainly don't want to think of it as an investment vehicle because you can't leave the money to anybody in a pooled income trust. So if you don't spend it, the money's lost. It's, if you were to die or go into a nursing home, whatever is left in your account stays with the trust, essentially goes to charity.
Yep. Okay, great. Does the discussion of the irrevocable trust also apply to supplemental needs trusts?
Well, supplemental needs trust is a whole different topic, and maybe Matt will want us to spend one of these hours talking about that. But it's a whole different thing, and needs a more detailed discussion, I think.
Okay, good. Let's see. Yeah, if you don't sell the house right after the grantor dies, but want to wait a year, should you get a home appraisal right after death?
Well, you're probably going to want to get an appraisal to establish what the date of death value is for tax purposes. But, you don't have to do that immediately. Appraisals can be done retroactively.
Okay,
if you waited a year and you decided you wanted to sell it, you could get an appraisal of date of death value. That shouldn't be a problem.
Okay. If you use a pooled income trust. Okay, this is gets a little into the weeds a bit, but if you use a pooled income trust for Community Medicaid, are retirement assets protected from Medicaid reimbursing itself?
Well, I'm not sure what the one has to do with the other here. If you are on Community Medicaid and you have a pooled income trust, you have that trust because you have surplus income, meaning you have income that's higher than the Medicaid limit, and you're putting your monthly surplus into your pooled income trust account. And once in that account, you can spend it on yourself. So that's one whole different thing. Your retirement account, the principal amount in the retirement account is an exempt asset for Medicaid purposes, provided that it is in payout status, meaning you are taking at least your required minimum distribution. Your required minimum distribution is income. So it is income that Medicaid will look at in computing your income budget and determining whether you have surplus or not. Okay?
Okay. Let's see. Somebody said, so Paul, thank you. Excellent presentation that everyone over 60 should hear. Just like the presenter, I put my mother's house into a trust, so she qualified for at-home Medicaid care. I have since put my own house into a trust so that I and my wife could also get aids at home when needed in the future. So this is, this is why planning ahead is useful, because you get Medicaid at nurse services in your home, and you can start the clock ticking in case you need to go into a nursing home.
Yep.
Okay, so here's I'm going back to the question that was a little bit more complicated. I don't know if you'll have time to, let's see. If you'll have time to answer this. Let's see. Sorry. Okay. No. Okay. If you have if a person has Community Medicaid with an MLTC and then transfers to nursing home for 1 month, then is discharged without the need for the Medicaid, does that person need to disenroll from Community Medicaid and MLTC if that person has a surplus and closed pooled trust? It seems like it would be unlikely for something like that to happen, but
I don't know. I'm having difficulty following that. So
yeah. So you know what? Maybe I think it was Judy. Yes, Judy, can you unmute yourself and ask that question? We're almost out of time, but I think let's see if we can get this one done.
We could always follow up later.
Yeah, maybe that we could do that. Okay. I think that's a good idea.
yeah.
All right. Good. Yeah. So I think that, what I always try to emphasize with people is that if you start seeing care needs coming up and you think that you might end up in a nursing home, planning ahead is really important because you can get help in your home, stay home as long as possible, and start that clock ticking for the 5-year look back. There are differences in community and nursing home Medicaid, but Community Medicaid, the goal is to help people stay in their homes as long as possible. So that's why applying for Community Medicaid really can help you keep, make your money last as long as possible while you're in your home. Okay.
All right. Well, thank you, everyone. This has been a really great presentation and obviously a lot of interest, a lot of great questions, a lot of people very interested. So, and with that, we'll thank everybody and say goodbye and see you next month.
Everybody.
Thank you, Matt. And thank you, everyone, for joining us today.